Good morning. It's a pleasure to welcome Andrew Cayley, Chief Co-Prosecutor of the Extraordinary Chambers in the Courts of Cambodia, more familiarly known as the Khmer Rouge Tribunal, to Washington University School of Law today. And we are really happy that Andrew Cayley could join us today. Andrew, thank you so much for coming to Washington University School of Law and for agreeing to participate in our Global Law Talks series.
Thank you very much indeed for inviting me and for your gracious hospitality. It's been very enjoyable the last 2 days.
Thank you. And Andrew, you have a very distinguished resume. You have a great deal of educational and professional experience. Before coming to the Cambodia Tribunal, you were at the ICTY as prosecutor. You were at the ICC as prosecutor. You've also been a defense lawyer, and you've served in the British Army. So with your permission, I'd like to talk to you a little bit about how those experiences have shaped your approach to international justice and how international justice is playing out at your current job.
Sure. Okay.
So as a British lawyer, you started in private practice, is that right?
Yeah, I was in private practice from 1987 to 1991. In 1991, I was commissioned into the British Army. I spent time at the Royal Military Academy, Sandhurst, then with the infantry for a while, and then I was a military legal advisor and military prosecutor in Germany for nearly 3 years.
So that experience as a military lawyer, how much did you apply or see applied the laws of war that you're now applying as a prosecutor in your tribunal?
Well, I think in those years, the law of war, international humanitarian law, had largely lain unapplied for nearly 50 years. But I think I took two things with me to the practice of international criminal law. The law of armed conflict, international humanitarian law, and also actually what I found even more useful in the end was the understanding of military structures and how armies, military forces are controlled. That was extraordinarily useful in prosecuting cases where we were prosecuting high-level military commanders who were often denying responsibility and trying to essentially bamboozle judges about how armies actually work. In my experience, I was able, along with military experts, to reconstruct military organizations and basically put the jigsaw puzzle together so that we could present the real picture to the judges.
Absolutely. And this is experience then you took with you when you went to the ICTY.
Yes, absolutely.
So what cases did you prosecute at the ICTY?
A large number. You may have to interrupt me as I go through them, but the cases I investigated a very large number of cases. I was involved in the prosecution of the General Blazkowicz case. I was involved in the General Krstić case, which involved events in Srebrenica in July of 1995. Then I was involved in the General Talic case, which involved the sort of vast ethnic cleansing of northern Bosnia between 1992 and 1994. Then I was involved in the prosecution of the Starkic case, which was the case involving the mayor of Prijedor. Then I was involved in the first prosecution of members of the Kosovo Liberation Army. That was actually the last case that I prosecuted. But I made a number of sort of appearances in a number of other cases where there was an issue of military expertise kind of evidence, because obviously, you know, where those kinds of experts were called, it was very easy for me to have a dialogue with a witness like that because I'd served in an army.
Right. And how large was the prosecutorial staff at the ICTY approximately when you were there?
It's interesting because at the beginning it was quite modest. I think there were about there were then actually about 30 UN regular staff, then many seconded staff from the United States government, from the Department of Defense, the Department of Justice, and the State Department. The court was very fortunate to have those people. And that took us up, I think, in the early years to probably about 60 or 70 staff. But certainly by 2000, you know, when the court was at its busiest, maybe a bit later, 2003, 2004, I think there were then probably about 350 staff in the OTP.
Wow. And so that was a pretty big operation by the end. And you were handling multiple trials, multiple cases at the same time.
Yes.
How does that compare to your work now at the Extraordinary Chambers?
The Extraordinary Chambers as you know, we only have 4 cases. They're pretty big cases. But if you can imagine, we're probably about sort of 20% of the size, 25% of the size of the ICTY because of that. Also uniquely, the Khmer Rouge Tribunal, because it's a domestic internationalized court, it has not only foreign international lawyers like me, but it also has Cambodian staff, and we work alongside them. So not only are we prosecuting these very complex cases and trying to ensure that international legal standards are met, but we're also trying to build capacity within the Cambodian legal system at the same time.
Right, and that's starting to take place in Yugoslavia as well, isn't it?
Yes.
Where I know I've heard that the folks from the region are actually coming to ICTY to get training. Absolutely,
and if you recall, I can't remember the exact date it was established, but the War Crimes Chamber that was set up in Sarajevo still has a number of international staff. It commenced its work with quite a large body of international staff working alongside local prosecutors and judges. I think that's diminished over the years. I mean, the comparison is an interesting one to make. What I would say is I think at least in the former Yugoslavia, in Bosnia, there were qualified judges and lawyers. The problem in Cambodia is that the Khmer Rouge murdered all of the judges and lawyers. So the legal system was built from scratch 20 years ago. So capacity has a long way to go. There is actually, I think, a larger need for international staff in Cambodia than in Bosnia, although relations, I think, probably in Cambodia can from time to time be a lot more strained than they are in Bosnia.
Mm. And you had a passage at the ICC as well, didn't you? Also as prosecutor.
Yes.
And there you had the Sudan case primarily as your responsibility.
Yes.
So tell us a little bit about that case.
Well, that was a case that, interestingly, was the first Security Council referral to the court. So it was an historic moment. It was also a case that was shepherded really from the Security Council to the court by the late Antonio Cassese, because he was the chairman of the Cassese Commission of Inquiry, which was a commission of inquiry set up by the Security Council in September of 2004 to report on alleged abuses within Darfur. Cassese actually, frankly, and I'm not just saying this because he passed away recently, he did an absolutely remarkable job. I mean,
he was a remarkable man.
Yeah, he was. And in the space of 5 months, armed with a Security Council resolution, he went into the Sudan and gathered a lot of evidence that was then presented back to the Security Council with a recommendation that the matter be referred to the ICC.
And once the matter was referred, your office was denied access, weren't you, to Sudan itself?
That's not quite the case. In essence, what happened was, you're absolutely right in the sense that Sudan immediately stated, we didn't sign the Rome Statute, we are not obliged to cooperate. And then there was a lot of debate about where their obligation to cooperate actually came from. Did it come from the Rome Statute, or did it actually come from the Security Council resolution? And of course, they were a member state of the United Nations. But it is true that their cooperation was very limited. We did, in fact, go on 3 or 4 visits. I can't exactly recall. It was either 3 or 4 visits to Khartoum, where I wouldn't say the government cooperated. They certainly met with us. They presented us with information that I think they wanted to present us with. But then, as soon as the application for the summonses to appear in respect of the first 2 individuals were made, all cooperation shut down with the International Criminal Court.
Mm. Well, that makes it very difficult, doesn't it? Because how can you build a case without access to evidence?
It does, although there were some remarkable finds of evidence actually outside the country. We were able to interview refugees in Chad. These were people who had to cross over the border because they'd been forcibly displaced during the conflict. We were able to interview individuals across the Middle East and in Egypt who were dissidents. We actually had to be very careful operating in Egypt because obviously the relations between those two countries are very close. But I will actually tell you one account of an absolutely extraordinary woman that we found in South London. We got a telephone call, and I think I may have told you this account before, but it's a very moving account, and it actually was a remarkable piece of evidence. We got a telephone call from the Home Office in London, who essentially is responsible for our immigration service. And a young woman, a doctor from Sudan, had recently arrived as a refugee. And it turned out that she was actually a member of the Fur tribe, which is actually one of the tribes that rebelled against the government, and it's one of the tribes that was essentially targeted by the government, where they were targeting the civilians from that tribe because they regarded all of them as rebels. She was a young doctor. She'd been a student activist against the government, so they had sent her to quite a remote sort of medical reception centre after she'd qualified. In that particular town, in 2003 or 2004, I can't recall the exact year now, there had been an attack by Arab militia, particularly on a girls' boarding school. And these Arab militia had gone into this boarding school, and it was a notorious event, and they'd raped, I think, upwards of 20 of these. I mean, they were children, most of them, I think, aged anything between 6 or 7, and teenagers, 14 or 15. After the militia left, these young girls were actually taken to that medical reception centre, and she examined these girls literally within hours of this event. So in essence, we had the medical evidence,
right?
Which
you had direct testimony.
You normally never get this kind of evidence. So we had the medical evidence. A non-governmental organisation immediately came to see her to talk to her about this event because they wanted to go public with it. She gave them all of her notes of the examination, and immediately after this non-governmental organisation left, the Sudanese security services arrived and basically told her, you need to keep your mouth shut. You need to tell nobody about what's happened here. Anyway, the NGO came back the next day. They did try to be discreet, actually. A number of people, and I've told this account before, asked me, why on earth did the NGO expose this poor woman? I think they tried to actually be discreet about it. But they came back again to speak to her. She spoke to them. Within half an hour of leaving, Sudanese security services arrived. She was arrested, and she was taken to these security camps, which they have. I mean, the Sudanese government spends more money on security and intelligence than on any other part of the governmental apparatus. She was taken to the security camp, and this came out at the end of the interview, and she was gang raped for a week and essentially told, we're doing this to you to make you realise that you need to keep your mouth shut. Now, of course, I mean, absolutely awful events, but not only did we have medical evidence demonstrating that these children had been sexually assaulted in incredibly violent circumstances, but we also had evidence where we could make the allegation that this sexual violence was government policy because they had taken this woman and essentially abused her in order to silence her. So it was extraordinary evidence.
How did she get out?
She managed to get on a British flight flying to London. She just basically managed to get through, as sometimes happens, God was watching. And she got on this flight and got to London.
Yeah. That's astonishing. You've also been a defense lawyer in these cases.
Yes.
So you're familiar with these terrible atrocities. You obviously empathize with the victims. And at the same time, you've represented individuals as notorious as Charles Taylor.
Yes.
How has that been for you? How do you like it? How is it different? Do you get upset about some of the atrocities?
I think, in a way, as a human being, we all react to these atrocities, and I think when one stops reacting as a human being, one should get out of the business, actually. But I think in terms of defending people, as I said yesterday to the students, I think it's also extremely important to put the prosecution to proof on these cases because largely we're dealing with very senior people, so we're not dealing with people, we're not actually dealing with the rapist on the ground or the individual who pulled the trigger. We're dealing with high-level people. And it's absolutely necessary to ensure that these cases have integrity. And that the prosecution, for example, discloses all of the exculpatory material that they have in their possession, that things are done fairly, that witnesses are properly cross-examined, that it's revealed that witnesses have perhaps received incentives to give evidence, which, as you know, in all of these courts, this issue has arisen. So for me, that side of it is the clinical part of the job. It's necessary for these people to be properly defended. In the early days, you'll recall, there were a number of commentators, including from scholars, not you, but scholars like yourself, commented actually that the quality of defence often was very poor. And what kind of integrity or strength does that give to the law that comes out of these cases if, in fact, the accuser's not been able to say everything that he should have been able to say, both in terms of the facts and the law? I think it made me a better prosecutor. I think it made me take, being involved in those two cases, also the Chermak case, made me a much better prosecutor in the sense that I took disclosure obligations much more seriously. I would add that Chermak was actually acquitted. Out of 3 accused, we managed to get an acquittal for him. And indeed, a lot of that, and I'm not, there were a number of people working on that case, not just me, but a lot of that acquittal boiled down to expert evidence, expert military evidence that we'd secured in that case.
Interesting. And now let's talk about the Khmer Rouge Tribunal, where you're currently the chief co-prosecutor. That is a tribunal that's very different than the others. It's covering an event that happened many, many years ago, an event that was probably the worst genocide since World War II. I think, by most accounts. Yep. And it's an event where there's politicization as well, because the former Khmer Rouge are still in the government, and you're working in a very difficult situation. So what motivates you to work on in this tribunal?
Well, I think it is a very interesting place to work. I mean, it's very demanding, because of the political issues that exist in the country that are connected to the court. But again, as you said, and in the slide that I showed yesterday to your students, 25% of the population was either murdered or died within a space of 3.5 years. There isn't anybody in that country that you can meet that's not in some way connected with those events in terms of having lost a relative. You will often speak to children that were born after the Khmer Rouge, and they will tell you that, for example, of their 2 parents, one of the parents is the only surviving member of an entire line of a family, for whatever reason. The only person that on that side of the family, they have no relatives at all. They have no uncles or aunts or cousins or anything, because that particular individual, their father or their mother, was the sole surviving individual. Everybody else
it's astonishing.
Disappeared.
It's astonishing.
Yeah, the scale of it is truly shocking, actually.
It's hard to imagine. So have you had to go out and do forensic evidence and visit mass grave sites and actually visit locations in Cambodia where massacres took place?
I've been to these locations. The only difficulty today, as I mentioned, I think yesterday to your students, is that the quality of forensic evidence now is very poor. There's a number of reasons for that. First of all, immediately after the Khmer Rouge were deposed by the Vietnamese who invaded the country in 1979, a lot of these mass graves were dug up by people looking for valuables, because a lot of these victims had had their valuable items sewn into their clothing, people looking for their relatives. And actually the exhumation largely, there are exceptions, the Vietnamese did do a couple of exhumations that were done for legal purposes, but largely graves were not exhumed for the purposes of forensic examination. And where graves were exhumed simply to, create memorials, the remains were left out in the weather. And the bones have, disintegrated over time because of the sun, because of animals. I think I didn't show it, but there's one example where there was an exhumation. All of the remains were placed in a building, and then gradually the building fell down, and now and I think I've got sort of 3 slides showing the progression, and now the entire site's been cleared. There's nothing left. There's another mass grave, a notorious mass grave, which is now a cashew plantation. So, time moves on.
Time moves on. And yet for people, the memory of what happened is so alive. Are your hearings well attended when the first trial, was it well attended by Cambodians?
Yeah, I mean, I always slightly exaggerate the size of our public gallery, but it's certainly the largest of any international court. I think it does literally hold somewhere in the region of 250 people, actually. It's huge. I mean, it wasn't designed as a court, it was designed as a military theatre. It's on a barracks, it's on an old Cambodian barracks, but it has a very large capacity. And in fact there, and I've said this before, the court's been extremely good about that. They've been very committed to bringing people in from the villages, from the provinces, and allowing them to see the process taking place.
So that didactic purpose is being filled pretty well.
Yes.
There's understanding of what the court does in Cambodia, and there's participation by victims.
You have to remember that we're dealing with a developing country. A lot of people are not very well educated, so it's necessary to actually explain the purpose to them of what's going on. They need to understand who the parties are. These are the judges. This is the defence. This is the prosecution. These are the civil party representatives. So an effort needs to be made, but actually it is made by public affairs who, to be quite frank on that front, I think the court has been successful. I know the Special Court for Sierra Leone actually got an award for its outreach programme, but I do believe that hopefully one day when the court completes its work and the legacy is examined, I think people will say that they did a good job on outreach.
That's terrific. And what about the trial itself? You've completed one trial, there's a judgment. What were the most significant accomplishments of that judgment and that trial in your view?
I think the most significant achievement was to actually get through it, and see it to a conclusion, because it was not easy. And to be frank, I didn't try the case. The staff in my office did actually. William Smith, my deputy, was principally responsible, because Robert Petit, my predecessor, actually had to leave midway through the trial for personal reasons. So, in fact, William Smith is the man that's really responsible for running that case in very difficult circumstances where a lot of staff were leaving, and he did that, it's fair to say, almost single-handedly, so he deserves a lot of credit for that. I think the achievement in the end of that trial was obviously that ultimately Doik was convicted. I think secondly, it sounds like a small thing, but one of the really astonishing achievements was the fact that he was given credit for the period of illegal detention, and that was agreed by all of the judges, including the nationals. And one must recall that actually Hun Sen, the current Prime Minister, actually was the man who was responsible for ordering that. So the fact that the judges actually, the national judges agreed with the international judges that, yes, this was illegal, he needs to be given credit for that, that was quite a jump for them. But they did it.
It shows some commitment to the rule of law.
Absolutely,
right.
That they were prepared to essentially go against the government on that issue. It sounds like a small thing, but when they did come out with that, I was delighted, actually, because sometimes they can actually dissent on that kind of issue, because of a feeling of pressure. That case is now under appeal. We did the appeal in March. Principal ground of appeal was sentencing, where we asked for an increase in sentence. Essentially, we wanted a life term. That would have to be reduced to a finite term simply because of the period of illegal detention, but we felt that there needed to be some kind of symbolism, bearing in mind, this man was responsible for the murder of upwards of 12,000 people, that he should get a life term. Reduced, I think we said, to either 42 or 45, I can't recall now. And then a number of other issues arose about cumulative convictions and the status of international customary law between 75 and 79 and how that applied to certain charges, whether or not certain crimes were criminalised during that period.
Right, which is very difficult, of course.
Yes.
There's very little law, and
Right.
and it takes a lot of parsing of the precedents. Yeah.
And we were actually oddly in the position where we were looking forward to the ICTY because they made decisions, based on the same sort of fallow period to say that these crimes actually existed. So I know it might sound a little bit sort of weaselly as a lawyer, but I was trying to argue, well, look, Your Honours, I mean, if the ICTY found that it was a crime in 1995 by looking back, and there was absolutely no development in the law between 1979 or 1975 and 1995, then it must have been a crime in 1975.
So they're quite difficult cases legally.
To make these arguments,
Yeah, and you have 3 cases now, case 2, case 3, and case 4,
yes.
correct?
And case 1 awaiting an appeal.
And case 1 awaiting the appeal.
Yeah.
And so what is the prognosis for the court? How long do you think it will take to get through these remaining cases? Will you get through the remaining cases?
Well, case 2 has been severed, so they've split the charges in that. They want to do the case in phases, which I actually think is a good idea. I disagreed with the judges, I mean this is a public matter, it's not a secret, about the manner in which the phases were done. But I certainly agreed that we had to do it in phases because otherwise there's a real prospect that these individuals could pass away. I mean, they're very elderly. They're all in their 80s, I think. They're all now in their 80s. They're not all in the best of health. That was always a risk. And so it would be phased. So I think we will at least get to some kind of conclusion in case 2. I don't know for what, whether the full scope of criminality that has been alleged in the closing order will be addressed, but we'll certainly get some determinations in respect of some of the charges. 3 and 4 is more complex. Those are still under investigation. The government are against those cases. This is a public matter. There's been quite a lot of sort of heated debate of late. The international investigating judge resigned 3 weeks ago. I was trying to really press these cases to move them on. There was resistance from the investigating judges who really wanted to shut them down very quickly. It's actually quite difficult at the moment to say what the prognosis is because we're awaiting a new international investigating judge, and it really depends on what he does. That's Judge Kasper Ansemet from Switzerland. But it is a very difficult situation because we are, in an environment where there are external pressures trying to essentially retard the process. And part of the concern that the government has is national reconciliation. They had to bring a lot of the Khmer Rouge into the government. So it's not something that's an entirely sort of speculative problem. I mean, it is a problem, but of course the argument that I have is that you've got to allow due process to take place. You can't allow this external factor to influence the legal process because what kind of example is that for the rest of the legal system?
Right. And if the court essentially only completes cases 1 and 2, what kind of legacy do you think that will leave in Cambodia?
I think it will be a partially constructive legacy. I think, and I've always said, in terms of cases 3 and 4, if they were able to come to some kind of legitimate conclusion, which I think is quite difficult, but at least you could come, 3/4 of the way to a legitimate conclusion, as opposed to sort of 25% conclusion and the rest of it is complete nonsense, how it gets there. That's the argument I've always had. We need to try and make sure that these cases, in the way that they're handled, do as little damage to case 2 as possible and give as little ammunition to defence lawyers to say, well, look how unfairly and wrongly these cases have been addressed. How can we even trust the evidence that was gathered in 2? That's the problem. And actually, that's what's going on at the moment. I mean, this is why I was a bit late this morning, is that the defence lawyers for Nguyen Chia have filed civil suit in Phnom Penh against the Prime Minister for interference in the case.
Yeah, so the politics that swirls around your court really it has the potential to derail a lot of the good work that's going on.
But the Undersecretary General O'Brien from Office of Legal Affairs in New York has been to Cambodia, in fact, last week. I mean, I was with her. What day is it today? Saturday? Friday.
Friday.
Sorry, Friday.
The life of the international prosecutor.
Sorry. I was with her on Friday, and she came from New York. She stated to the government, look, you know, there cannot be political interference in this process. So, you know, the UN, I know the UN's come under a lot of criticism over this, but, you know, the fact that she came and said that does now demonstrate that the UN is committed to this process and they want it to be as fair as possible.
Absolutely. So just one final question. We're almost out of time. You've had this brilliant career. You're doing such important work. What advice would you have for young people today, our young law students who look at you and would like to be you, basically? How what should they study? What should they do if they would like to do this kind of work?
I mean, I think in many respects, training in criminal law and criminal procedure and trial experience in domestic courts is actually a prerequisite for doing this work. What I often find is that young, very enthusiastic students come forward and they want to get into this line of work with absolutely no domestic experience. Of course you need the academic training, you know, in international humanitarian law, public international law, international criminal law, but you actually need, you know, hands-on experience of domestic trials. I was extremely lucky because I went into the army, you know, when I was 26 years old, and in the army you tend to, because of the way our army prosecution service worked then, you actually got exposed very early on in your career to quite large, complicated criminal cases, which you probably wouldn't have been exposed to in, you know, if you'd been working in civilian life. But that's the experience you need. So my advice to anybody who wants to get into this field is, you know, do an internship while you're a student with one of these courts or, you know, with the ICC. Then, after you've done that and you've studied the right subjects, you know, international criminal law, you know, human rights law, public international law, international humanitarian law, then do criminal prosecution work in a domestic court, in a district attorney's office, with the federal prosecution service, even as a public defender. Either with the federal service or with a state public defender's office, and then make application to go and work in one of these courts. And I always advise people, I mean, it is very hard to get into this field now. You know, I came in, you know, in the early days, you know, through the cat flap, you know, when there wasn't much competition, to be frank. I was very, very lucky. But I think now you just have to keep being persistent. Just be persistent, because eventually, you know, the good people do get their breaks. There's absolutely no doubt in my mind about that, and there's plenty of examples that I can give you of people who've made it. You have to work very hard. It's an extremely demanding field. You know, you'll work as hard in one of those courts as you will do in a big New York law firm where you know, you'll earn 4 times as much. But, you know, that's the devotion, I suppose, that people have to this cause.
Yeah. Well, Andrew, thank you so much. Thank you for giving of your time and your energy to all your work in Cambodia
my pleasure.
and to coming to Washington University.
Thank you for inviting me. Thank you.